course, in the dock. What you're seeing in that particular frame there in the gallery is Tony Forbes among the people who are there to track developments as they unfold today. Interesting because Tony Forbes spoke to our Jade Pulsar, part of our team inside court a short while ago, and mentioned that as far as he's concerned, the mastermind of this hit is still out there somewhere. Of course, they want to see some kind of progress in this particular trial, but even a year down the line, they're incredibly devastated, one can understand, by what happened in February last year. Once again, as soon as proceedings begin, we'll be back live to you or for you in the Durban Magistrates. there for a formal bail application. Finally, some people might say, you might remember the last time we'd watched the story unfold, it was for bail verification, more of an administrative process, if you like, the confirming of things like residential addresses, identity documents, etc., etc. And Tony Forbes is among the people in the gallery there. In fact, you might be able to spot him with his bright blonde hair. He has already spoken to us, saying that, of course, they have an interest in seeing this matter through, especially because of how closely related they are to the story. And so we'll get a sense of how things unfold. And then
that when we start with the matter, we give space here. So I'm calling the magistrate. Thank you very much. Yeah.
All rise in court. As is please the court, Your Worship, I request to call case number 23/2156 of 2024, the matter of the state versus Lindokuhle Mkhwanazi and 4 others. It appears today at court number 12 in the Durban Magistrates Court. It appears before Mr. Vivi Hlachwayo. For the state is myself, Advocate Drava, duly assisted by Advocate Dwega. On the record for accused number 1 and accused number 5 is Advocate Mlochwa. On the record for accused number 2 and accused number 4 is Advocate Volmarans today. For accused number 3 on the record is Ms. Gilling. Ms. Lamini is assisting us with the interpretation of this matter. It was adjourned for the date of today for purposes of the accused intention to bring an application for their release on bail, which application is opposed by the state. Your Worship, there's just 1 or 2 issues that I will address the court after my learned friends have confirmed their appearances on behalf of the accused.
Thank you, Mr. Mlochwa. May it please the court. Your Worship, I confirm my appearance on behalf of accused number 1 and number 5 in the matter.
May it please the court, Your Worship, I confirm my appearance on behalf of accused number 2 and 4, and I'm instructed by Mr. Sizwe Taylor, who is present. I will bring an application of sorts to Your Worship once we've finished with the introductions.
As court, please, Your Worship, accused number 3, confirm my appearance on behalf.
Thank you, Your Worship. It just came to our attention after we have seen, Your Worship, in chambers that there is lack of water in this establishment, which will necessitate that the proceedings might have to sit until 1300 hours for today because of that situation. So whatever we do today, we request that we keep that in mind. And then the second issue, I think Mr. Volmarans can address the court there.
Thank you, Mr. Volmarans.
Thank you, Your Worship. Your Worship, at this point, we had been given instructions regarding the drafting of the affidavit, particularly in respect of accused number, well, in respect of both my clients, accused numbers 2 and 4. It has now come to our attention that we have to effect certain additions to the affidavits, and we don't have the means to do it here and now because it's quite extensive. For that reason, Your Worship, I'm requesting the court to give us an opportunity to stand down in order to effect those additions to the affidavits. However, Your Worship, I don't know what Your Worship's attitude is, whether it's the same as your brother Singh in Court 11, but unless everybody is present and all the legal representatives are present, he is not prepared to proceed. So unless Your Worship orders that the matter proceed in respect of those accused who are ready now in our absence, that is Your Worship's decision. that is my application, that as far as accused number 2 and 4 are concerned, that the matter stand down for us to effect those additions and amendments. Thank you, Richard.
Mr. Tava, what is the state's attitude?
Your Worship, I'm under the impression of the following. It has also been whispered in my ear by Mr. Mlochwa that accused number 5's application is not necessarily ready for today. They still have to finalize the compilation of their affidavit. However, I'm of the view, subject to what my learned friends are saying, that those that are ready today, in the presence of those that are not ready, we can read those affidavits up to their finality and them deciding whether they are closing their case at that stage. Then we adjourn to the 18th for those that still have to bring forward their applications, and we deal in the same process. Thereafter, the state will then decide what to do. Instead of having today's proceedings shortened in this fashion. Today is a Thursday. Of the view that Mr. Volmarans might have to, after the adjournment at 1300 hours today, a chance to do all those amendments either tomorrow, today, Saturday, Sunday, and then we come on Monday for those applicants that are not ready today. My only difficulty is the following. It would have been better that we term them as per their accused name numbers. If it's accused number 1 who brings here, it will be applicant number 1. If accused 2 brings, it will be applicant number 2, as per the charge sheet. However, now the applications might not go according to that sequence, which then might give us a little bit of a problem. I'm not sure whether we might say, this is accused 1 who's applicant number 3, applicant number 2 still has to bring his application, I don't know, but that is my suggestion.
My understanding that the application is going to be brought by way of affidavits.
As far as accused number or applicant 2 and 4 is concerned, that is correct, Your Worship.
So too for applicant 3, Your Worship.
So is the position of this applicant number 1 and applicant number 5?
With those who are ready, and the fact that applicant number 1 will be followed by applicant number 3, as far as I'm concerned, is not much of thing to bother about. At least we would have dealt with applicant number 1 and applicant number 3.
All I'm requesting, Worship, is seeing that number 2 and number 4 are not ready. We will say accused number 1 is applicant number 1. Accused number 2 or applicant 2 not ready. We're dealing with applicant 3
Yes.
and applicant 5. If we go within that fashion, then it's better.
Yes.
So if my colleagues agree, then we can perhaps start with that.
Mr. Mlochwa, all right. The applicants may be seated for the time being. Mr.
Thank you, Worship. Then, Your Worship, before we start, I would request to hand in a certificate confirming that by the Office of the DPP that in view of counts number 2 and 3, and in the list of the charges, they fall under Schedule 6 of the Criminal Procedure Act. Also of the view that my colleagues are not in opposition to that. We are at idiom, but just for the completeness of the record, I would request to, I've handed the copy to them. May I hand same and it be marked as Exhibit A for these proceedings.
Thank you. You confirm, ladies and gentlemen?
Yes, please, I do confirm, Your Worship.
The document referred to by Advocate Gweba, a certificate by the Director of Public Prosecution dated 14 March 2024, is accepted into the record. It's marked Exhibit A. Thank you.
If you wish, at this stage, accused number 2 and 4 have not been graced with a copy of the certificate. Thank you. Marlon, please.
It is so delivered as quickly as 2 seconds.
Thank you. Thank you. Mr. Mlochwa, are you ready to proceed?
Yes, Your Worship.
Thank you. You
Your
may
Worship, as
proceed.
the record will indicate that in discharging an honors that rest upon applicant number 1, being Mr. Lindoguhle Tabani Mkhwanazi, he will be placing reliance on an affidavit that he has deposed to, including the annexures thereto. Your Worship, may I ask leave to hand up the original of the affidavit so that the court can follow as I read it onto the record.
Thank you. That will assist.
Sorry to interject. I would request that I know sometimes there's a different school of thought that section 6011, capital letter B, A and C only applies when one testifies, but our case law now has since advised us that even if it's by form of affidavit, the applicant should be warned. I would request that before Exhibit A is, or rather, the affidavit is read, that all 5 applicants be given the warning in terms of section 6011, capital letter B.
You're quite correct, Mr. Kwe. Thank you for that.
Thank you.
Gentlemen, the accused, you are warned that the testimony you'd be giving in these proceedings may be used against you during the subsequent trial. I appreciate and understand that you are not taking the stand, but I, for completeness sake, have to say that the answers that you give may also be used against you. You are not obliged to answer any questions, although you are not taking a stand. Just for completeness sake. You are obliged to disclose if you have any pending cases or previous convictions against your names. Disclose this information is a criminal offense for which you, if convicted, you can be sentenced. Thank you, Mr.
In the Magistrate Court for the District of Durban, held at Durban, case number 23/2156 of 2024, in the matter between Lindoguhle Tabani Mkhwanazi, the first applicant, accused number 1, Lindani Zenzele Shisela Ndimande, the second applicant, accused number 2, Sianda Edi Mieza, third applicant, accused number 3, Nziwetemba Harvey Kwabeni, fourth applicant, accused number 4, Lindoguhle Lindo Ndimande, the fifth applicant, accused number 5, and the state as the respondent in an application for bail in terms of section 60, subsection 11A of the Criminal Procedure Act 51 of 1977. First applicant's affidavit in support of application for bail. Your Worship, it will appear according to the paginated and index papers on page 1. I, the undersigned, Lindoguhle Tabani Mkwanazi, do hereby declare under oath as follows. The introduction, paragraph 1. I am an adult male and the first applicant in the interlocutory bail application proceedings, but accused number 1 in the main criminal proceedings.
Lindokuhle Mkhwanazi iyona affidavit leyo ucela khona ibheli iqala ngokuthi ke kuzibike ukuthi ke igama lami nguLindokuhle Mkhwanazi ngumuntu wesilisa omdala okuyena ke umangalela wokuqala kuleli cala futhi kuyena kumceli webheli wokuqala.
Paragraph 2, this is a founding affidavit prepared in support of an application for my admission to bail.
Affidavit yami le efungelwe ke ekuyona ke ezolekelela ukuthi ke ngicele ibheli.
Paragraph 3, the facts to which I depose herein are true and correct unless the contrary appears or the context otherwise indicates.
Konke lokho kubhalwe phansi kuyiqiniso futhi ngiyakwazi ngaphandle uma ngase kwenzeke kube khona ke okuvelayo ukuphikisa lokho.
Paragraph 4, where I depose to in respect of the law, I do so on the advice of those representing me, and such depositions must be viewed and understood in that context.
Konke okubhalwe phansi lana ukumayelana nomthetho konke kubhalwe ngosizo labameli bami. Ngakho ke konke lokho kuzobe kubhalwe lana kuzomela ukuthi ke sikuzwise ngendlela abameli abasuke beyibone ngayo.
Paragraph 5, where I place reliance upon information that I've gleaned from people upon whom property value depends, I will make eloquent effort to attach confirmation thereof, with special regard being had to the time constraints, bail application being urgent by its very nature in law, and circumstances in detention in the preparation for this bail application.
Lapho ke kuzobe kuvele khona ke ukusizwa kubantu abathile ngizobe sengifaka ke izinto lapha kule affidavit ezizoba zisiza noma ziseka lesi sicelo nokuthi ke futhi kukhunjule ukuthi ke isicelo sebail siyinto ebalulekile futhi ephuthumayo.
Paragraph 6, where I make averments of a legal nature herein, I do so upon the advice of my legal representatives, whose advice with no qualms whatsoever I accept to be true and correct.
Lapho kuzobe kubhalwe khona izinto eziphathelene nomthetho ngizobe ngisizwa ummeli wami okuyena ke owazi kabanzi ngomthetho.
Paragraph 7, I must hasten to add that in the light of the fact that paragraph 7.1, that I've not had any access to the police case docket in connection with this matter, as I verily believe that I'm only allowed access once investigations are complete and the matter is ripe for trial. And 7.2, that though it is taken for granted that transparency is one of the ideals post-constitutional liberal democracy, my instructing attorney was unable to get the state to advance the grounds of opposition to bail during our very first appearance in this honorable court. I'm therefore unable to make complete submissions to the allegations by the state against me in this matter. For the sake of brevity, other than terse reply by the state that this is a Schedule 6 matter, I've not been furnished with grounds of state's opposition to bail.
Lapha ngifisa ukuchazela inkantolo ukuthi ke bengingakanikezwa ithuba lokuthi ke ngibone zonke izinto eziphakathi kule dokodo elavulela lecala leli ukuze ke ngatshela ukuthi konke lokho kuyobe sekuyaveza uma ngabe selilungile ukuthi lingakoqulwa icala njengoba ke uphinde futhi uveza la inkantolo ukuthi awukwazi ukuthi ke usho kabanzi ukuthi yini eyenza ukuthi ke baphikisane nesicelo sakho sebail uchazeliwe kodwa ukuthi ke lesi sicelo sebail sizobe singaphansi kuka Schedule 6 ubungakotshelwa futhi nokuthi ke yisiphi isizathu esenza ukuthi baphikisane nebheli yakho.
Paragraph 8, I'm acutely aware that I am innocent of the charges that the state has preferred against me. I, however, have been advised by my legal representatives of right to remain silent, and I'm advised further of the supreme significance regarding availing oneself of such right, particularly at this infancy stage, especially if and when regard is had to the fact that I'm not privy to the contents, affidavits, documents, statements contained in the docket to substantiate the charges against me. Notwithstanding, I nevertheless will endeavor to account and explain as best as I can my defense to the allegations that the state has leveled against me.
Okwamanje ngifisa ukubika ukuthi ke ngiyazazi ukuthi ngimsula kule cala noma lamacala engibhekene nawo. Phezu kwalokho ke ummeli wami ke ubengichazelile ilungelo lami lokuthula ngingasho lutho, ngaphinde futhi ngachazelwa kabanzi ukuthi iqonde ukuthini lokho lapha enkantolo, ikakhulukazi uma ngabe ke kuhlelo olufana nalolu lebheli lapha enkantolo. Kukhona ke futhi phansi ama affidavit nezinto engizixhumele kona ama affidavit. Khona futhi engingakutshelwanga ukuthi edokodoni kukhona ini ubufakazi njengamanje, kepha ke ngizozama ukuthi ke ngayo yonke indlela ngichaze enkantolo ke ngendlela efanele ukuthi ke la ngizivikela ngokuthini ecaleni.
Public interest, paragraph number 9. By virtue of the fact that we live in a modern digital world, that both deceased were known by general public, and the right to freedom of expression, including among others, freedom of press and other media, it is not surprising that the matter has generated and continues to generate a great deal of public interest, regardless of the sub judice principle.
Ngenxa yekhathi esiphila kuzona ke izikhathi ke lezi ke zamaselula nayo yonke into, umufi noma abafi bobabili kuleli cala leli abantu kade baziwa kakhulu emphakathini. Ngakho ke ngiyazwisana noma ngiyabona ukuthi ke kwenziwa yini ukuthi lecala leli libeke namehlo amaningi kangaka alibhekile ephuma lapha yana kumaphephandaba kanye namalunga omphakathi.
Paragraph 10. Consequently, I must pause to indicate that I've been reminded by my legal representatives, which reminder I find encouraging, especially if and when regard is had to the considerable attention that this matter has attracted in the media platforms and in the media, of the words of the judges in the Republic of South Africa in the previous 2 cases that attracted media and public on the same scale as this matter.
Phezu kwalokho ngifisa ukusho ukuthi ke ngikhunjuziwe ke abameli bami ukuthi ke icala leli liyalandelwa kakhulu ke amaphephandaba kanye nabo bonke abantu ke beyinkundla zokuxhumana, nanokuthi ke ngaphambilini ke futhi umeli wami ungichazelile ukuthi akhona amanye amacala acaphuniwe la ayekade ke ebhekwe kakhulu ke yiso la wonke umuntu ezweni lase South Africa.
Paragraph 10.1, Judge W.J. van der Merwe, in the rape case in State versus Zuma, 2006, volume 6, SACR 191, Witwatersrand Division, as it then was, handed down on 8 May 2006, held in the introduction of the judgment as follows.
Icala lokuqala ke leli licashuniwe ke icala lango 2006, icala ke lelo lalibhekene noZuma ke ebekwe icala umbuso.
It must have been clear from the beginning that I will not allow myself to be influenced or distracted by anything or anybody. A judicial approach cannot be anything else than impartial, objective, fair, and totally dedicated to the task lying ahead. Whatever my conclusion at the end of the judgment may be, the outcome will not satisfy everybody. At no stage whatsoever did I intend satisfying anybody, and I will certainly not do it now. This trial has created an unknown interest among the public at large and received enormous media coverage, printed as well as electronic. It was difficult not to see and hear some of the comments, in spite of the fact that I try not to read, look, or listen to the news concerning the matter I'm busy with in court. Some matters, unfortunately, did not escape my attention.
Kulelo cala ke lelo ke kuthiwa ke ijudge lapho ke elakudalula ukuthi ke lapha ya kulela cala ke kwakusobala ke ukuthi ke ijudge ke lisithole libhekene necala la kukhona khona ke abantu bamaphepha kanye nabantu amalungu omphakathi amaningi ke bezolalela leli cala leli kodwa ke leli judge lithi kazange lize likudedele lokho ukuthi ke lifike esinqumeni esingafanele lathe malizothatha isinqumo ijudge lakhumbula ukuthi ke akusiyi wonke umuntu ke ozojabula ngesinqumo sakhe kodwa futhi ke kunjalo kwakufuneka ukuthi kulandelwe umthetho kungabi khona into ke ezomvala amehlo noma kube khona into ke ezomenza ukuthi ke asabe ukwenza umsebenzi wakhe ngendlela efanele lecala leli ngalesikhathi likhona lapha kuleya nkantolo malungu omphakathi wonke ayefikile ezolalela ke kwangalindele ukuthi kuzofika nabantu bamaphepha ngale yandlela afika ngayo kwakunzima ke ukuthi ke ijudge lingaboni izinto ezibhaliwe emaphephandabeni kanye nakuwo noma social media kepha ke ijudge lelo lithi ke lakwazi ukuthi liqhubeke lenze umsebenzi walo.
Paragraph 10.2, similarly, Traverso Deputy Judge President in State versus Diwani, open brackets, CC 15 of 2014, close brackets, open brackets 2014, close brackets, ZAWCHC 188, handed down on 8 December 2014, paragraph 24.7, stated as follows. I realize that there is a strong public opinion that the accused should be placed on his defense. I have taken note of that. I've also taken note of the plight of the Hindochas. I have, however, taken an oath of office to uphold the rule of law and to administer justice without fear, favor, and prejudice. That I cannot do if I permit public opinion to influence my application of the law. If any court permitted public opinion which has no legal basis to influence their judgments, it will lead to anarchy.
Icala lesibili ke la elicashunwe abameli bakho icala ke ekwakuyela Diwani eboshwe umbuso elenzeka ngo-2014 lapho ke lelo judge lelo lalikade lilalele la lachaza kabanzi ukuthi ke bese lizwile ukuthi ke baningi abantu abakhulumayo ukuthi ke labasola labo kwakumele basiphendulele enkantolo bekhuluma ke indawo zonke kepha ke lelo judge lithi ke lafunga ukuthi ke lona liyokwenza okufanele nokubulungiswa ngakho ke ngeke lalingeke lize lenze umsebenzi ke kube khona umuntu ekubona sengazi uthi ke wenzelwa ke ufefe futhi ke kuzobonakala ukuthi yonke into ayenza inobulungiswa engeke futhi aze adedele ukuthi ke amalunga omphakathi athini noma ke amgxeka athini.
Paragraph 10.3, I must edify reference to the above mentioned two cases in that though the judges made these remarks in the judgments after hearing evidence in the trial proceedings, the approach adopted by the judges in relation to public opinion is relevant to public opinion in these bail application proceedings.
Yafisa ukusho ukuthi ke kulokho ke okwachazwa yilama judge amabili lawa macala amabili omabili lama judge afika ke enqumeni ezihlukile ezingafani kepha ke okwakukhona futhi okufanayo njengamanje ukuthi ke kwakukhona amalungu omphakathi ayekhuluma izinto eziningi le ngaphandle kepha ke futhi lapho amajaji aqhubeka ngokwenza umsebenzi wawo namanje kulecala leli ke ubhekene nalo uyachaza ukuthi kusayinto efanayo akhona amalungu omphakathi ke anezinto zawo abayishoyo kodwa ke futhi ke la isicelo sebail sibhekene nawo.
The charges and schedule of bail application. Paragraph 11. Inherent in the charge sheet and its annexures is that I have been charged with conspiracy to commit murder, 2 counts of murder, unlawful possession of semi-automatic firearms, unlawful possession of ammunition, 5 counts of attempted murder, and money laundering. The culminating point, therefore, is that the matter falls within the purview of Schedule 6.
Kulamacala ke lawa ngichazeliwe ke noma kubhaliwe kuyona i-charge sheet ukuthi ngibhekene namacala amangaki nokuthi athini kuyachaza ukuthi ke ngibhekene necala ke lokukhanda kwakha itulo lokubulala amabili okubulala icala ke lokutholakala ngiphethe isibhamu ngongekho emthethweni icala lokutholakala ngiphethe inhlangu zokudubula isibhamu ngongekho emthethweni amacala amahlanu okuzama ukubulala kanye necala ke leli lokushushumbisa imali lamacala wonke ke sekhona ke kuchaziwe ukuthi ke kuzoba ke ku schedule 6 lapha enkantolo.
Paragraph 12. Accordingly, it is unnecessary for the Director of Public Prosecutions of KwaZulu-Natal to issue a written confirmation in terms of Section 60, subsection 11, capital letter A, subsection A of the Criminal Procedure Act 51 of 1977, herein after referred to as the Act, to the effect that she intends to charge us with offense or offenses referred to in Schedule 6.
Ngakho ke ukuthi uyachaza ukuthi ke asikho isidingo ke noma ke bengekho isidingo sokuthi ke ukuyena umlawuli wabashushisi lapha ke KwaZulu Natal ukuthi ke akhiphe ke incwadi eqinisekisayo ke ukuthi ke amacala lawa noma amacala esibhekene nawo uzimisele ngokuthi ke kuba amacala angaphansi kuka Schedule 6.
Paragraph 13. I now know and understand fully that Section 60, subsection 11, subsection A of the Act enjoins me to adduce evidence which satisfies this honorable court that exceptional circumstances exist which in the interest of justice permit my release on bail.
Ngiyazi ke futhi ke ngitsheliwe ukuthi ke njengamanje ke kulindeleke ukuthi kube mina ozokwazi ukuthi katshengise inkantolo ngobufakazi ukuthi ke nginezimo ke nezizathu ezihlukile futhi ke ezikhethekile ezingandele umuntu phezulu lokho futhi ezizoba ubulungiswa ezingenza ukuthi inkantolo ivume nokuthi ngithole ibail.
Justice Ishmael Mahomet in State versus Achasin 1991 volume 2 SALR 805 made a remark that is to date the foundational principle in the consideration of bail, that an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice.
Lapha ke kwakade kuchaziwe ngaphambilini ukuthi ke umuntu uma ngabe ke eboshiwe ke angeke aze agcinwe ngaphakathi edoksini kuze kube icala lifike emaphethelweni ngenxa yokuthi ke uyajeziswa nje kuyathiwa ke kule lizwe esiphila kulona ke umuntu uma ngabe ke eboshiwe ngokusemthethweni lo muntu lo ke usuke ke emsulwa kuze kube ukuthi ke inkantolo emthola enecala ke imgwebe ngecala. Inkantolo ke ngokujwayelekile ke iyele ikhiphe ibail noma imnikeze umuntu ibail uma ngabe ke ibona ukuthi kubulungiswa ukuthi athole ibail inqaba nayo kuphela mangabe kubonakala ukuthi ke angeke kuze kube ubulungiswa.
Declaration regarding previous conviction or convictions and pending charges. Paragraph 17. If the court may bear with me. I have been advised and I now understand fully that in terms of Section 60, subsection 11, capital letter B, subsection A of the Act in bail proceedings, the accused or his or her legal advisor is compelled to inform the court whether Roman figure 1, the accused has previously been convicted of any offense, and Roman figure 2, there are charges pending against him or her, and whether he or she has been released on bail in respect of those charges.
Ngichazeliwe futhi ke ngezwe ukuthi ke umuntu uma ngabe ke eboshiwe ke ezocela ibail uyele lo umuntu aphoqeleke ukuthi kayitshele inkantolo uma kuukuthi ke uke wagwetshwa icala ngaphambilini enkantolo noma uma kuukuthi ke kukhona amanye amacala noma elinye icala asalihamba kwezinye inkantolo esengaphandle ngebail kulona lelo cala.
Paragraph 15, I've been advised further that in terms of section 60, subsection 11, capital letter B, subsection D, that an accused who willfully, Roman figure 1, fails or refuses to comply with the provisions of paragraph A, or Roman figure 2, furnishes the court with false information required in terms of paragraph A, shall be guilty of an offense and liable on conviction to a fine or to imprisonment for a period of not exceeding 2 years.
Ngichazeliwe ke futhi ukuthi umuntu ke ongakhulumi okuyiqiniso noma ke oyikhohlisayo inkantolo ngalokhu lo muntu ke angabhekana necala uma ukuthi lelo cala ke futhi ke liyamlahla enkantolo angagwetshwa ke iminyaka engafika futhi ingadluli kwemibili noma ahlawuliswe.
Paragraph 16, accordingly, I declare that I do not have previous convictions, but on 8 January 2024, this court granted me bail in case number 23/13377/2023 of 5,000 rand in charges of conspiracy to commit murder, unlawful possession of automatic firearms, and unlawful possession of ammunition. For completeness' sake, I have attached the charge sheet, its annexures, and exhibits that were presented during bail application as Exhibit A.
Ngakho ke ngiyafisa ukuthi ngidalule phambi kwenkantolo ukuthi anginawo amacala kangilahla ngaphambilini kepha umhlazu 8 kuJanuary 2024 yona lenkantolo ke yanginikeza ibail ecaleni eline case number 23/13377 of 2023 lapho nganikezwa khona ibail ya 5,000 rand. Amacala engangibhekene nawo kulelo cala lelo kwakuyicala ke lokwakha itulo lokubulala, elokutholakala ngiphethe isibhamu ngongekho emthethweni kanye nokutholakala ngiphethe inhlamvu zokudubula isibhamu ngongekho emthethweni. Kuze ke konke kuphelele kahle ngifakile la kulesicelo sami i-charge sheet yakuleyo nkantolo ukuze kubonakale yonke into.
Paragraphs, personal circumstances. Paragraph 17, I have very strong ties with both my family and Matwaleni community in Mtubatuba. I am an adult male aged 30 years as I was born on 29 December 1993. I attended Nkosentle Primary School and Bizimali Senior Primary School in Mtubatuba.
Nginomndeni ke endaweni yasemadwalweni eMtubatuba ngumuntu wesilisa omdala oneminyaka u30 ngazalwa mhla zu-29 kuDisemba ngonyaka ka1993 ngafunda esikoleni Inkosenhle Primary kanye naseBizimali Senior Primary School eseMtubatuba.
Paragraph 18, I have lived for most of my life at my homestead with my father, Mr. Tulani Mantinga Mkwanazi, my mother, Mrs. Mbali, Princess Mkwanazi, my two sisters, Miss Talent Nosipho Mkwanazi, and Miss Lungelo Stembiso Mkwanazi. The investigating team verified my physical address, and my parents and my wife are always in court to give me support whenever this matter is in court.
Endaweni ke yaseMtubatuba ke ngihlale khona ke cishe impilo yami yonke ngihlala nobaba wami ogama lakhe uThulani Mantinga Mkhwanazi, umama uMrs Mbali Princess Mkhwanazi nabo dade bethu ababili uMiss Talent Nosipho Mkhwanazi kanye noLungelo Sithembiso Mkhwanazi. Umseshi ke noma abaseshi kuleli cala leli bakwazile ukuthi ke bayoqinisekisa ke ikheli lami lapho ngihlala khona nabazali bami kanye nonkosikazi wami bahlezi befika lapha enkantolo ukuze ngiseka.
Paragraph 19, to obviate replication, I humbly implore this honorable court to consider Exhibit LTM 5 attached to Exhibit A, the charge sheet of the matter wherein I was granted bail as incorporated herein as Exhibit LTM 5 is confirmation of proof of residence by Honorable Councillor MP Ndlovu of Ward 14 in Tubatuba, my ward.
Ukuze inkantolo yaneliseke ke khona la kulesi sicelo ke ngixhume incwadi ke evela ekhanseleni ke uMP Ndlovu wase Ward 14 eMtubatuba oqinisekisayo ukuthi ke ngiyahlala kule kheli engilibhalile.
Paragraph 20, I am married and my wife is Mrs. Hlengiwe, Princess Nyati. The date of marriage is 23 June 2023. Again, Annexure LTM 1 and LTM 2 to the charge sheet is the marriage certificate and my ID smart card.
Ngishadelwe unkosikazi wami uMrs. Hlengiwe Princess Nyati usuke sashada ngalo umhla ka 23 June 2023 khona futhi lana ke ngixhumile ke isitifiketi somshado kanye ke ne-ID yami.
Paragraph 21, we do not have children together, but my wife is currently pregnant with my first child. I attached a medical certificate and X-ray scans as annexures LTM 3 and LTM 4 to the previous charge sheet. The updated ones will be Exhibit B.
Asinazo ingane ndawonye nonkosikazi wami kodwa kokwamanje unkosikazi wami uzithwele ngengane yethu yokuqala futhi ke khona lana ke kuyona le affidavit yami ngifakile ke isitifiketi somshado kanye ke nezikeni eziphuma ke esibhedlela la zixhunyiwe ku charge sheet le yasekuqaleni kanye futhi kule yanamhlanje zikhona futhi.
Paragraph 22, my wife is a qualified educator and she holds a Bachelor of Education, B.Ed degree, and an honors degree in Education Management, both obtained at the University of South Africa, UNISA, in 2018 and 2020, respectively. In the sea of unemployment prevailing at the moment, my wife is so fortunate in that she is employed by the Department of Education of KwaZulu-Natal in Gwavuma area. For work purposes, she rents a room in Gwavuma, but without fail, is always back at home during weekends and when schools are closed.
Unkosikazi wami ke uneziqu ke zokuthisha noma zokufundisa nokuthi ke ngenhlanhla anayo ke emveni kokuthi ke la kulezo imisebenzi ingekho kangaka ube nenhlanhla yokuthi ke aqashwe ke umnyango wezemfundo khona lapha endaweni yaseNgwavuma ngokomsebenzi ke uyele aqashe lapha eNgwavuma ahlale khona kepha ke njalo ke mangabe kuphela isonto uyaya ekhaya noma izikole ezivaliwe usuke esekhaya.
Health status, paragraph 22. I have chronic sinus and asthmatic health conditions for which I receive chronic medication. In this regard, I've attached the medical certificate from my medical practitioner as Exhibit C.
Ngokwesimo sakho sempilo ke ngiyachaza ke enkantolo ukuthi ke nginesifo ke sesifuba kanye nayo isinus la ngele ngithole khona ke imithi njalo ngifakile ke la nesitifiketi ke sivela kodokotela bami ukuze inkantolo ibone.
Passport, paragraph number 24. I have a valid passport, but I handed it over to the investigating team during the first successful bail application with my undertaking that I will not apply for another one until the finalization of my court cases. I reaffirm the same undertaking in this matter, taking this honorable court into my full confidence that I will respect this honorable court's directive not to apply for the new passport until my court cases are finalized.
Nginayo ke i-passport esemthethweni ke kepha le passport ngayinikeza ithimba labaseshi ngalesi sikhathi ke ngiboshwa kokuqala ngifaka isicelo sebheli sokuqala futhi lapho ngafunga ukuthi angeke ngize ngiyoyibhalisela i-passport entsha namanje ke ngisafisa ukuyithembisa inkantolo ukuthi ke ngisanomqondo owodwa ukuthi ke ngalesikhathi icala lisakhona lapha kule nkantolo liqhubeka angeke ngize ngiyofaka isicelo sokuthi ngibe ne-passport entsha.
Assets, paragraph 25. As aforementioned, I and my wife live at my parental homestead, but the two of us have built our own house at the same homestead. The cost for building the house are estimated to be in the region of plus or minus 200,000 rand. It even became necessary for my wife to approach Capitec Bank for 100,000 rand loan facility to assist in completing the building of the house. To date, my wife still finances the loan facility which I'm helping her with, hence my humble request to be admitted to pay. Exhibit D is Capitec Bank statement of the loan facility being currently serviced by my wife.
Njengoba bengichazile ukuthi ke mina nonkosikazi wami sihlala ekhaya emzini wasekhaya, kepha ke mina nonkosikazi wami ke sike saqala ukwakha khona lapha ekhaya. Ukwakha ke umuzi lona esiqalile ke singasho ukuthi ke kudingeka imali ke engafika ku 200,000 wamarandi. Sekuze kwafika ke isikhathi la unkosikazi wami edinge ukuthi aye khona ke ebank ayocela ukuthi ke anikezwe iloan khona eya 100,000 rand ukuze akwazi ukuthi aqhubeke nokwakha umuzi. Kuze kube manje ke unkosikazi wami ke uyena osayikhokhela ke le loan lapha ayithatha ebank, nami ke kumele ngimlekelele ukuthi ke ayikhokhele leyo loan. Kuyisicelo sami ke ukuthi ke ngikhishwe ngaphandle ngebail ukuze ngizokwazi ukuthi ngiqhubeke ukuthi ngimsize unkosikazi wami. Ngifakile ke statement sase bank khona la kulesi sicelo ukuze ke inkantolo izocaciseleka.
Paragraph 26, I consider myself blessed for having the wife that I have, who is so supportive to me financially, regardless of the fact that she earns a salary of 21,000 rand per month, the gross salary. Her pay slip is Exhibit E.
Ngithatha njengomuntu obusiseke kakhulu ukuthi ngibe nonkosikazi okwazi ukuthi angeseke onginikeza ngisho nokungeseka ngeindaba zeimali. Yize ke unkosikazi wami ehola imali engango 21,000 rand ngenyanga. I pay slip yankosikazi wami ngiyifakile la ukuthi ke inkantolo ibone.
Paragraph 27, the area we live in falls within the jurisdiction of Inkosi Ntokozo Mkhwanazi, who I fervently believe to be not averse to my release on bail.
Indawo ke esihlala kuyona ke isesigodini sika Ntokozo Mkhwanazi engikholelwa ukuthi akanankinga uma ngabe inkantolo inginikeza ibail.
I see it shortly after 11 o'clock. No intentions to detain everybody, maybe.
I'm not sure. In light of the fact that we started so late, can we allow Mr. Mlojo to proceed and finish the affidavit? Is there any objection to that?
May I approach Ms. Lamini?
Yes.
On the last occasion, I was told that I did not pay attention to her. I don't intend to do that today. She will request a 5-minute adjournment. She needs some water because she's been talking so long without any bottle of water next to her. So she feels she's dry. She'll learn to arrange for that.
Is it just water?
Just water. That's what she relayed to me.
Maybe I can suggest maybe 10 minutes, 15 minutes, short adjournment.
My other proposal, Your Worship, was that if there's not too much left, it can be interpreted to the accused whilst in the cells in the adjournment so that we can dispense with the interpretation. Because it does assist with time that we do not have much of.
Yes,
but it's up to the applicants themselves how they wish to deal with that aspect.
Especially in the light of the fact that we can only sit up to 1 o'clock.
That's correct, Judge.
Yes. Okay, the time is now 3 minutes past 11. Are we agreeing on 15 minutes break?
Yeah, we can come back at 20 past 2.
Okay. What will adjourn until 20 past 11?
Right, not. Explain what is it? Afanda nayo. Nothing. Leaving you in charge.
Can you please check if this one? Level on channel 2. Nothing. It's fun.
8, I'm self-employed, own 2 taxis that operate under the Dugu Taxi Owners Association since the year 2020. My father is the one who financially helped me start in the taxi business industry with the money he received from his retirement. Annexure LTM 6 attached to the charge sheet Exhibit A is the confirmation by the Dugu Taxi Owners Association. LTM 7, LTM 8, and Exhibit B to the charge sheet A are the taxis logbooks. 29, I estimate that I collect plus or minus 40,000 rand a month from the 2 taxis before paying drivers' wages and other expenses. Exhibit F, G, H are my 6 months bank statements in respect of accounts I hold with Standard Bank, Absa Bank to show movement of monies in my bank accounts, including but not limited to deposits by my taxi drivers, payment of installments, insurance premiums, and tracker premiums. 29.1, I have an account at Capitec Bank. However, my wife could not obtain same due to the biometrics security. I am, however, willing to give the state the account number to verify. 29.2, my wife could only obtain 6 months bank statements on both my Absa and Standard Bank account. Paragraph 30, I also support financially my sisters, Ms. Talente Nosipho Mkhwanazi and Ms. Lungelo Sthembiso Mkhwanazi with their kids. In this regard, reference is made to confirmatory affidavits, annexures LTM 9 and LTM 10 to the charge sheet Exhibit A. Paragraph 31, for lack of better words, detectives are literally clutching at straws, desperate in this matter, in that they don't have anything to link me to the offenses, especially if regard is had to the time lapse between the alleged incident and my arrest by the police. The arrest, paragraph 32. On the afternoon of 12 December 2023, as I was driving in Tuba area, I saw a car suspiciously following me very closely. The occupants of the car announced that they were police and that they wanted me to stop on the side of the road. Paragraph 33, I indeed stopped the car in full compliance with the instruction. They thereafter approached me and informed me that they were police. They further informed me that they were executing arrest upon me in connection with the death of Mr. William Kunene. Paragraph 34, after my arrest, they traveled with me from Tuba to Durban, ultimately arriving shortly before 1900 hours in an area called Isipingo, if I'm not mistaken. It was the end of the trip from rural Tuba area, but the beginning of my travel with and in the hands of the police. Paragraph 35, the assault upon me by the police started immediately. Though I had been told when arrested in Tuba that my arrest was connected with the death of Mr. William Kunene, I was greatly surprised that during this assault brought to bear by police upon me and also tubing me, they were demanding me to make a confession statement to the matter of a well-known musician, Mr. AKA, instead of Kunene matter for which I had been arrested. I denied steadfastly any involvement with the matter of Mr. AKA. Paragraph 36, other than the denial of involvement in the matter of Mr. AKA, I never resisted arrest but cooperated fully with the police. I was thereafter detained from Tuesday, the 12th of December 2023, until I was granted 5,000 rand bail by the learned magistrate, Mr. Singh, in this very same court on 8 January 2023. In this regard, bail receipt is attached to the charge sheet Exhibit A. Paragraph 37, among the terms and conditions that the learned magistrate, Mr. Singh, prescribed for my release on bail was to report daily at my nearest police station, Mtuba. From date of my arrest from the date of my release on bail until the day of my arrest again on 27 February 2024, in connection with this matter, I have been fully complying with all bail terms and conditions. Moreover, I never fled despite knowing from the date of my arrest in the other matter in December 2024 that I was also being investigated by police in connection with Mr. AKA incident. Paragraph 38, though I'm a layman, but after the assault by police that was intended to extort confession from me, I summarily reached a conclusion that the state is skating on a thin ice as it does not have evidence linking me to the offense or the offenses. Paragraph 39, I will plead not guilty during the trial proceedings and put the state to proof thereof. I'm willing, prepared, and ready to take this honorable court into my full confidence that I will be found not guilty if this matter proceeds to trial. Paragraph 40, in fact, I will instruct my legal team that this matter stops after the state case by applying for a discharge in terms of Section 174 of the Criminal Procedure Act 51 of 1977. Paragraph 41, the reasons for asking for bail are as follows. 41.1, I have not been furnished with copies of the state witnesses' statements. Therefore, I do not know the identity of the witnesses, and in terms of Section 60, subsection 4C of the Act, will not intimidate or threaten any of the state witnesses. 41.2, I support my family and my siblings' kids financially. 41.3, my detention is really an anticipatory punishment as the state does not have evidence to sustain the charges. 41.4, I will stand trial in terms of Section 40B of the Act as I want to prove my innocence. I never fled even though I became aware of my possible arrest for this matter during my first arrest in December 2023. 41.5, I will comply with the conditions the court deems appropriate to accompany release on bail in accordance with Section 62 of the Act. 41.2, my release on bail will enable me to raise money to pay for the services of my lawyers. 41.8, my release on bail will also help me to help my wife finance loan facility she took for our house at my homestead. 41.9, it is my desire to support my wife during her pregnancy until she gives birth to the baby, and it is my wish to be also physically and emotionally present when the baby is born. 41.10, my release on bail will not endanger the safety of the public in terms of Section 60, subsection 4A of the Act. 41.11, I will not commit any offenses while on bail. 41.12, I will not undermine proper functioning of the criminal justice. 41.13, my release on bail will not disturb the public order or undermine the public peace or security. 42, though my legal team has advised me that this honorable court has judicious discretion in respect of the terms, conditions, and amount in relation to bail, my wife has, however, raised an amount of 3,000 rand for bail. I must reiterate that my wife is the person who paid my 5,000 rand bail in the other matter. The strength of the state case, paragraph 43. Despite the fact that I'm a layman, my legal representatives have advised me that the state case is extremely weak, despite long list of charges, and there is a strong view of splitting or duplication of charges. 43.1, conspiracy to commit murder and murder, counts 1 and 2. My legal representatives have very strong, sound, and persuasive argument to present if and when this matter proceeds to trial, in that these two counts constitute splitting or duplication of charges. The learned author C.R. Snyman in criminal law clearly defines conspiracy as an inchoate, formally defined crime, whereas murder is a complete, materially defined crime. Hence, more often than not, the rule of practice is that the former is an alternative to the latter. 43.2, the charges of money laundering do not make legal sense, do not satisfy the legal requirements, and do not have the requisite points A, B, and C. For clarity's sake, point A is first point of origin of money, with point C as destination point, with point B as a laundering or washing or cleaning up point so that the dirty money reaches point C, looking clean or normal. Bizarrely, the charge sheet of money laundering in this matter do not have point A as a point of origin of payment, thereby making inference irresistible or inescapable that point A is just an innocent point. Therefore, money laundering charges will not stand the legal test in its current form during the trial proceedings. Put differently, I'm advised that even if my legal representative do not make an application for a discharge after the close of the state case in respect of these money laundering charges, the presiding judicial officer during trial proceedings will mero motu consider the discharge. 43.3, I was never found in physical possession of any firearms and ammunition. Therefore, my legal representatives will be able to persuade the judicial officer during the trial proceedings that the possession of firearms and ammunition alleged by the state in this matter does not satisfy the legal requirements. In other words, the possibility cannot be excluded that the presiding judicial officer during the trial proceedings will not agree with the state that it is the only inference to be drawn and an inference that excludes all other inferences. 43.4, again, the attempted murder counts are extremely weak. Prima facie suggests that there are no injuries, and the state relies largely and heavily on sheer theorization. It appears as if the state will rely on circumstantial evidence, with great possibility that the trial court will not agree with the state that it is the only inference to be drawn and the inference that excludes other inferences. In fact, plethora of inferences flow from these attempted charges. Paragraph 44, it is now in the public domain, though not clear whether through deportation or extradition process, that the Republic of South Africa as a requesting country is desperately exhausting diplomatic efforts to approach Swaziland as requested country to bring back to the Republic of South Africa the two alleged fugitives. I have not had sight of the extradition papers. Therefore, I reserve my full rights to add, subtract, or edify anything in this bill application should information contained in those deportation or extradition papers become available to me. Wherefore, I humbly request this honorable court to admit me to bail, subject to the terms, conditions, and amount that this honorable court, in the exercise of judicial discretion, deems appropriate as exceptional circumstances exist that in the interest of justice warrant my release on bail. For the record, immediately after the affidavit of the first applicant is the affidavit of his biological father on page 19 to 20, which reads as follows. I, the undersigned, Tulani Mandinga Mkhwanazi, with the identity number mentioned, do hereby make oath and state, paragraph 1. The facts deposed herein are within my personal knowledge true and correct unless context indicates otherwise. Paragraph 2. I'm the biological father of Lindokuhle Tabani Mkhwanazi, who is the accused and bail applicant in the murder case of Mr. AKA. Paragraph 3. I wish to state that in the year of 2021, I took out a loan from Absa Bank together with my savings to purchase a Toyota Quantum on behalf of Tabani Lindokuhle Mkhwanazi. I wish to state that the money was loaned to me and he is still paying me back. Paragraph 4. I further wish to state that after I had assisted him in buying the said vehicle, he has money on his own accord to procure another Toyota Quantum. He thus has two taxis operating in the Durban area. Paragraph 5. I wish to state that I'm not involved in any way in the running of the taxi business, nor do I own any taxis. The taxi belongs to my son and he runs it by himself. Your worship, on page 21 will be the charge sheet of the matter that the first applicant is making reference to in his affidavit, 36 to 34 is the affidavit to which the investigating officer, warrant officer PA, deposed in the other matter where applicant number 1 was granted bail. Page 36 to page 43 is the affidavit in support of application for bail that the first applicant filed in the previous bail application that was successful before the learned magistrate, Mr. Singh. Page 44 will be the first applicant's marriage certificate with the wife he refers to in his affidavit. Page 45 is his ID, copy of his ID. Page 46, Your Worship, for the record, are the X-ray scans that he presented in the previous bail application to demonstrate the pregnancy of his wife. Paragraph 47 is the proof of residence that has been that was presented in the previous bail application. The proof of residence, the proof of residence letter was authored by Honorable Councillor MP Ndlovu. Paragraph 48 for the record is the letter from the Dugu Taxi Owners Association, which reads as follows. This letter confirms that Elchin Kwanazi, with the ID number, is a member of the Dugu Taxi Owners Association. He is a loyal member. Could you please assist him in whatever way that deemed necessary? Authored by the chairman of the association, Mr. Mbata. Paragraph 49 is the affidavit deposed to by one of his sisters, Nosipo Talent Mkwanazi, confirming she resides in Matwaleni, confirming she is unemployed, confirming she is the biological mother of the child, giving the ID number, and she is supported by her biological brother, applicant number 1, Mkwanazi Lindoguhle Tabani, with the ID number she gives. Paragraph 50 is the affidavit of applicant number 1's second sister, Lungelo Stembiso Mkwanazi, where she confirms she resides at the same area as the applicant and the other sibling, that she is a biological mother of the 2 children, and that the kids are being supported by her biological brother. She gives the name of the applicant before court. Paragraph 51, 52, 53, for the record, those are the taxi logbooks referred to in the applicant's affidavit. Paragraph 54 is the deposit of 5,000 rand bail that was paid by his wife, which bears the case number referred to in his affidavit, the applicant's name, as well as the particulars of his wife. Paragraph 57, for the record, the recent X-ray scan to show the pregnancy of his wife obtained from the doctor. Paragraph 58 is the obstetrician and gynecologist who is observing the first applicant's wife during pregnancy until she delivers. Paragraph 59 for the records, Your Worship, is the letter by Dr. R. Motley, who confirms that the above patient, that is the applicant Mkwanazi, with the ID number and the age 30, is a chronic asthmatic and hay fever sufferer. He has suffered exacerbations also with exposures to chemicals. Your Worship, on page 60 to page 126 is the Capitec bank statements solely to demonstrate the loan of 100,000 rand that the wife of applicant number 1 took to complete the house. That will be on page 60, Your Worship, as one casts a glance on page 60. Paragraph 127 for the records is the pay slip of the wife of the first applicant, Mr. Mkwanazi, confirming first her employment with the KwaZulu-Natal province, Department of Education, and her salary, and then page 128 to page 146. Standard Bank statements in respect of the account held by the first applicant, Mr. Lindoguhle Mkwanazi, as he refers to his affidavits to demonstrate the movement of monies in his account. Your Worship, on page 163 will be the birth certificates of the kids according to the first applicant's siblings, sisters. The first applicant is rendering financial assistance. And then, Your Worship, for the record, on page 167 is the copy of the ID smart card that belongs to the first applicant's wife. And then page 168, the copy of the first applicant's ID. And then the page 169 to the last page, the Capitec Bank statement in respect of the account that is held by the first applicant's wife. As called, please.
The affidavit by applicant number 1 is accepted into the record. It's handed in. It's marked Exhibit B.
As called, please. My apologies. It will appear that among the documents that has been presented, there is 1 or 2 that fell through the cracks. If the court may bear with me.
Sure.
My apologies, Your Worship. It would appear that there is another bank statement that fell through the cracks. Exhibit G, that will be on page 147 to page 155, is the bank statement in respect of the account held at ABSA by the first applicant, Mr. T.M. Mkwanazi.
Yes. It so appears.
Your Worship, that is the case for the first applicant.
Thank you. Case for the first applicant. Second applicant is not in a position to.
Reiterate my position as far
Yes.
as applicant number 2 and 4 are concerned.
Thank you, Mr. Volmorans. It is on record. Ms. Gilling, on behalf of applicant number 3. You may proceed.
Your Worship, just before I proceed, I have confirmed with my client that this does not need interpretation. I was downstairs with the court interpreter, with his affidavit, explained everything. That's where he signed the affidavit, so we need not interpret it into isiZulu, and he has confirmed, Your Worship.
Okay.
Thank you, Worship.
Do you have a copy for the court?
I have the original for court, Your Worship, if, with leave of the court, if my hands same up.
Thank you.
And then I'll read from the file copy, Your Worship.
Thank you. You may proceed.
Thank you, Worship. I, Eddie Siana Mayeza, a major male and residing at L28 Paula Crescent, Mlazi, and currently unemployed due to me remaining in custody for a lengthy period, awaiting finalization of my bail applications, do hereby make oath and state as follows. Contents of this affidavit falls within my personal knowledge unless the context indicates otherwise and are true and correct. Where I refer to legal principles, I do so on advice of my attorney. I am further aware that this bail application is proceeding as a Schedule 6 bail application. The interest of justice test has to be satisfied, permitting my release on bail in terms of subsection 64A to E of the Criminal Procedure Act, taking some 31 factors into account, enumerated in subsection 65 to 8 and 8 capital A. Subsection 64A, I have no previous convictions. There are no interim nor final protection orders against me. I have 3 minor children aged 5, 3 and 1. Prior to my arrest, during April 2023, for a matter before Mlazi Court under case number C74223, now transferred to Regional Court with a trial date to be set, I was employed at a Shisa Nyama near my home and earned 700 per week. I was released on bail by the High Court for the latter matter by end September 2023 and was in the process of seeking employment when I was arrested for this matter and a matter in Durban District Court 10, which court granted me bail. I have 2 pending matters for which I am on bail and 1 matter in which the bail application is partly heard in District Court 11, Durban. There is Mlazi, Chatsworth Regional Court, joint possession of a firearm, a pistol, on bail, appealed to the High Court. This matter is not ripe for trial. We await further particulars. It's Bekitemba Sabskas, 138/04/2023. Next court date is the 26th of March 2024. Durban District Court 10, murder, conspiracy to commit murder and various other counts such as possession of a firearm, on bail, DC 10. The matter has not been transferred to Regional Court as at date and remains in the receiving court. Mabel Sapskas, 26/5/22, the next court date being the 12th of April 2024. Durban District Court 11, murder, conspiracy to murder and various other counts such as possession of a firearm. The bail application is partly heard in DC 11. Berea Sapskas 53/3/23, the next court date being the 18th of March 2024. The pending cases in Durban District Court 10 and District Court 11 and this case before the Honourable Court predate my release on bail during September 2023 and therefore submit that this offence and the other pending matters are not suspected offences committed during the short period that I was on bail and not in custody. I further understand that Section 11 capital B of the Criminal Procedure Act requires me to disclose whether I have prior convictions and pending charges against me. I am also aware that in the event of me deceiving the Honourable Court in this regard, I may be imprisoned for a period not exceeding 2 years or a fine. The degree of violence in this charge against me cannot be disputed. It, however, is not indicative of me being a violent person until such time I am convicted of an offence with such a degree of violence. I have not made any threats to any person, harbour no resentment towards anyone, including the SABC members investigating the cases. They are merely performing their duties. My guilt or innocence does not rely on them, it relies on the evidence before the trial court. They are tasked with investigating the complaint and not tasked to judgment. I could therefore not harbour ill feelings or feelings of revenge against them for duly performing their duties. This offence was not committed during my short period of release on bail. Although the offences so charged with in this matter are prevalent in our province, it does not imply that persons in our area, being Mlazi, and the province being KZN, are predisposed to committing these or other offences. The Criminal Procedure Act was drafted before our Constitution and did not anticipate that the rights of an accused person would be jealously guarded by same. A presumption that all persons from Mlazi are violent, and because of the prevalence of these offences, all persons from Mlazi are predisposed to committing same, will not withstand the scrutiny of our Constitution, and the Honourable Court is asked to make a value judgment on the presumptions created by the factors enumerated in Section 60 of the Criminal Procedure Act. Subject Section 64B. I have been residing at my given address since birth. My residence is my family home where I reside with my mother. It has been said during my bail application District Court 10 on another matter by the same investigating team that the outside room that is allocated to me is uninhabitable and a shack. My possessions are meagre, my tackies and some clothes. This is submitted to imply that persons who are impoverished and unemployed are not entitled to be released on bail, having nothing to lose by fleeing. This is reprehensible in South Africa, as the presumption has no basis whatsoever. Unless the state can refer the Honourable Court to case law, which supports statistics referred to in respect of the propensity of poor persons to flee when released on bail, I submit the Honourable Court is evenly expected to apply the principle of the wealthy having the necessary means to travel, relocate and thereby fleeing the country by the state. Our Constitution, the presumption of innocence, preservation of dignity and numerous other provisions reserving the rights to accused persons does not envisage nor provides for the paralysis of the Constitution at the hands of the state where bail proceedings are concerned. Mere submissions that a poor person, even a homeless person, will flee if released on bail is abhorrent in our constitutional democracy. Something more substantial needs to be in evidence other than a submission that there is a suspicion. Umlazi falls within the region of this Honourable Court and is a stone throw away. In the event of this matter being transferred to Regional Court or High Court, it will in all likeliness be within the building of this Honourable Court and thus remain within the jurisdiction of this Court. I therefore reside within the jurisdiction of this Honourable Court. As a person of meagre means, I cannot afford to lose bail money, even if the amount is slight. My bail amounts were in the amount of 5,000 Rand each for my 2 pending cases. I can afford to pay bail with financial assistance of my mother and extended family, but most certainly cannot afford to lose the bail money. I have no travel documents, neither the means to travel outside the Republic. It is serious charges, admittedly so, but I am standing before court as an innocent man until such time I am convicted and a first offender. The punishment I could face is a lengthy period of imprisonment if convicted, but the length of imprisonment is not enough for me to attempt to flee and so implicate myself in an incident. I intend to plead not guilty when the matter reaches trial stage. The prospects of a conviction is further to be considered with reference to the strength of the state's case. Should the state's case be submitted to be fragile, the sentence or sentences are not a given but rather a remote possibility. I am therefore not putting the cart before the horse, contemplating conviction and setting my mind on a course that will prejudice me greatly in future. My pending cases are cited below, and so too the circumstances surrounding my arrest for this matter. Pending case 1, Becky Temba, SABC case 138-423, possession of prohibited firearm, a pistol and ammunition. The matter is now in regional court and almost ready to be set down for trial. I was due to appear in Umlazi Court for court whilst on bail for this matter, Umlazi C, court case number C74223, on 13 October 2023. I had very recently been released on bail for this matter during September 2023. The Durban High Court order was granted 28 September 2023 under case number D 9885-2023. I am the only accused in this matter, and the next court date for this matter is March 2024. Pending case 2, labeled SABC case 26-522. The charges are for murder, conspiracy to murder, and various other charges. I was arrested under the last court after my matter was adjourned to a future date, as my attorney and I walked out of court for the pending case herein. Labeled SABC case 26-522. During this verification, it was brought to the Honourable Magistrate's attention that the High Court granted me bail with full knowledge of this matter that I was alleged to be implicated in, as appears from the record, the affidavit of the investigating officer Parbu. I was granted bail in the amount of 5,000 Rand. The next court date for this matter is 12 April 2024 in Durban District Court 10. I advised my attorney at Umlazi Court that I was advised by the SABC prior to my appearance, whilst on bail, that I will be rearrested under Umlazi at my next appearance for another matter. This, SABC will dispute and have disputed, but I submit it is the truth, and nonetheless arrived at court prepared to be arrested. Despite the content of the affidavit of Parbu at Annexure A, for the purposes of the record, Your Worship, there is one annexure to this affidavit, Annexure A, that will be the matter in Umlazi Court that was transferred to Umlazi Regional Court sitting at Chatsworth, Your Worship. That will be the charge sheet, the affidavits of my client, Parbu, and the record of proceedings, Your Worship, the bail proceedings. Despite the content of the affidavit of Parbu at Annexure A hereto, citing no less than 6 serious cases, this specific case included, that I am allegedly linked to, the High Court having granted me bail with full knowledge thereof, I did not flee whilst out on bail for the Umlazi matter. I returned to court on the next court date and was arrested after the adjournment. Bail was granted on the 28th September 2023 and I was arrested at Umlazi Court on the 13th October 2023. Pending case 3, Ria SABC case 5323, I am still appearing in Durban District Court 11 for this matter and the ratification is partly heard. I am one of 4 accused in this matter. Our next appearance to continue this ratification is set down for 18 March 2024. The current matter, I was in custody on the SABC case 5323 awaiting finalisation of my ratification when I was charged with the matter before this Honourable Court. I do not have a valid passport. I submit I do not have any intention to travel outside the country, and further have no which is easily enforceable. I submit the numerous possible future cases for which I may be charged in future listed in Annexure 8 of the Tibz SABC case 138/422 did not prompt me to flee, as I duly attended the guy's court house on that. The latter supports my suppression that I am not righteous. Section 6011. I am not familiar with the evidence that will be brought against me in this matter, nor am I aware of the whereabouts of any physical evidence against me. I am therefore not in a position to conceal what is always saying. I further submit that given the event of me becoming aware of the whereabouts of the evidence, that I shall not conceal what is always saying. The latter evenly applies to any other pending matters against me. The evidence appears to be cellular phones and firearms in possession of the SABC. It is therefore submitted that the evidence is in possession of the SABC. In a safe place, and ostensibly the only witness statements could be outstanding in this matter, with the exception of phone reports of documented evidence and perhaps ballistic reports. I am not aware of the identity of any of the state witnesses in this matter, and pending matter, but undertake not to intimidate or influence witnesses if I were to be advised of saying, so jeopardizing my prospects at heart. Any such acts would most certainly reflect negatively on me speaking to guilt rather than innocence. I would not sabotage justice in such a manner at any time. The evidence is in safe custody of the SABC members and is not capable of being accessed by me. Concealment or destruction of same is therefore not possible. I have no relationship with the state witnesses, and if there are witnesses outside SABC members, I do not know their identity. I have no knowledge as to who the witnesses may be and do not intend to find out who they are. My interest is in my freedom, preparation for my pending trials, and maximizing the time by procuring employment to support myself and my children once on bail. My interest most certainly does not lie in making plans to harass, intimidate, or interfere with witnesses, try and locate evidence which is already under lock and key at SABC, so prejudicing myself before any of the matters come to trial, performing acts that will speak to guilt rather than innocence. Section 6011B. I did not provide false information to the SAPS at the time of my arrest and have not done so in respect of any other pending matter. I am not on parole, having no prior convictions. I further did not fail to comply with any bail conditions whilst on bail for the Mlazi matter. It might be submitted that SAPS members tried to find me at my home to arrest me on another matter, and I was not at home. They only found my uninhabitable room with a few clothing items. This does not imply that I was on the run or fleeing. This had been submitted in my prior bail application for the matter in DC 10 Durban in opposition to bail, implying I contravened the High Court order not resigning at my homestead. I submit I resided at my designated homestead throughout. That is where I suspect SAPS informed my family that they wished to arrest me. Had I been on the run, I would most certainly not have gone to Mlazi Court on the next court date, knowing that I would be arrested. I was simply not home when SAPS went to my home. Subsection 6011. I submit that the release of my bail would not result in public disorder, shock, and outrage. Should the Honourable Court, as it may be, should the Honourable Court experience an increase of members in the public interest in my release for this case, it should not reflect this outrage. And again, public outrage should not be inferred from media interest and an increase of members of public in the gallery. I submit that the public outrage referred to speaks of public as a whole of the Republic and not a few interested parties. Public peace, order, and security will not be disturbed or undermined. I submit that the interest in this matter lies in the status of the deceased persons as celebrities, and not in myself, nor me possibly being released on bail. There have been no protest or banners at court during my first two appearances calling for refusal of bail. My life will not be in danger if I were released on bail. The onus lies on the state to show that exceptional circumstances exist showing that my life will be in danger. I submit that no exceptional circumstances exist. The Honourable Court requested that I and my co-accused reveal our faces in full sight of the media and public gallery during our first appearance after the state confirmed unequivocally that our lives would not be in danger should our identities be released. Neither would it affect identification by state witnesses, as the state does not intend to conduct an identification parade at any time. Subsection 11A, exceptional circumstances. I am not aware of the content of the opposing affidavit of the investigating officer or officers in this matter, and am further unable to anticipate what the submissions, whether on affidavit or orally, of the investigating officer will be. As it is my application, I commence somewhat blindly as to the state's case against me in opposition to bail. I can therefore only speak to the strength of the state's case in a limited manner, but submit that I will be able to show the above Honourable Court that the state's case is artificially bolstered for the purposes of bail with multiple charges. The strength or fragility of the state's case will be evident after evidence of the state's case through its witnesses, and I humbly request that the Honourable Court considers my attorney's submissions during her address on the state's case if it should become clear by the time of her address that the state's case is in fact somewhat fragile. I have not had sight of the contents of the criminal docket and related evidence against me, and I'm therefore electing to decline to refer or comment on the allegations against me, bar for denying that I committed the offences set out in the annexures and intend pleading not guilty at trial. There are, however, circumstances and information that will be revealed during this bail application through the state's evidence, my co-accused evidence, and cross-examination of the state witnesses, if any, my affidavit and my attorney's address or closing argument that will show the above Honourable Court whether the state's case is capable of being addressed in respect of the strength or weakness and should be taken as exceptional circumstances in the event of fragility being apparent. I submit that the exceptionality of the circumstances is that I did not attempt to flee whilst out on bail for the Mlazi matter. I had personal knowledge that I would be arrested after my court appearance there, but still attended court. Surely something more substantial should be before court to convince the court that I will flee should I be granted bail. The fact that both the High Court and myself were aware that this case and several others were possible pending cases against me at the time of me being granted bail in the High Court, Annex A, shows that the High Court clearly deemed my release on bail just by having granted me bail. This alone speaks to exceptional circumstances. I submit that the High Court order is being undermined with the state's opposition to bail in this matter in an effort to keep me in custody. This pending case was within the High Court's knowledge at the time of me being granted bail, and so too within the knowledge of the state, service of process on the state. It is evident that the state did not deem it necessary to oppose bail on appeal, with further submissions on pending cases cited in Padwa's affidavit at the time of the appeal having been considered. If this was indeed a consideration, it did not weigh in favour of opposition, implying that bail is in essence not opposed in totality to the existing application and cited pending matters. The intention of the order of the High Court was not to leave a door open for arrests on all other cited cases. If this were so, bail would not have been granted on appeal. Continued arrests are anticipated to be piecemeal, the first having been effected on the 13th of October, for which matter I was granted bail in Durban DC 10, on the same grounds as set out herein in respect of my release on bail by the High Court. I am aware that my release on bail stands on two legs. The Service of Justice permitted my release on bail, and thereafter to show that exceptional circumstances permit my release on bail. It may be said that my personal circumstances alone do not amount to exceptional circumstances, but I submit that exceptionality of the circumstances can be revealed during the state's evidence and during address. The existence of exceptional circumstances does not have to be revealed during the applicant's case and its affidavit alone. Evidence before court remains evidence, even if it were placed before court during the state's case and challenged during address. In this regard, I submit that my evidence in my affidavit is capable of being challenged by the state after having heard my application, but that I am not given the opportunity to challenge the state's evidence if theirs is given by way of affidavit. The only manner in which the state's evidence is capable of being challenged, if by way of affidavit, is by challenging same during address. If oral evidence is given by the state, my attorney will challenge same during cross-examination. I therefore ask that the Honourable Court take into account my attorney's submission and during cross-examination when considering my release on bail. This is dependent on the Honourable Court permitting supplementary answering affidavits from the applicants. That would be answering affidavits to the state's affidavit, Your Worship. Counts 1 to 12, the counts enumerated requires some discussion herein. The applicants are charged with all counts. Count 1 is conspiracy to commit murder in respect of Kiernan Forbes. Counts 2 and 3 refers to the murder of Kiernan Forbes and Tebela Motswane. It is submitted that a conviction on murder and conspiracy to murder would be an error on the part of the trial court, as proven facts that speak to conspiracy to murder could only result in a conviction of murder, not both. Reference is made to Ngogo versus S, 852-202-2021, ZA SCA 166, 3 December 2021, that has reference herein. Conspiracy is not capable of being proved solely on telephone calls made and received near the area in which the incident occurred. More will be required by the state from the defence at trial. In Mbanyaro and another versus S, 8271-2007-2008, ZAWCHC 45, 2009-1, SICR 631C, on 11 August 2008, Judge Musa delivered judgment on 11 August 2008, in which he held as follows. In my view, the mere presence and running away from a scene of a crime with the perpetrator do not meet the requisites of common purpose. The trial court held that the presence of the second appellant on the facts of this case go beyond mere presence and in itself constitutes an act or acts of association that are sufficient to satisfy the requirements for the establishment of common purpose. I cannot agree. In my opinion, that finding is clearly wrong and a misdirection, that it stretches the doctrine of common purpose beyond reasonable and legitimate boundaries. The elements of the offences in all counts include intention. In respect of intention or dolus, the element stands to be proved by the state at trial, and Masingili and others versus SA 44812, 2013 ZAWC HC 59, 2013 2 SACR 67, WCC on 20 March 2013, the court held as follows. It is incumbent upon the state to prove the perpetration of aggravating circumstances as defined in Section 1(1)(b) of the CPA during the first stage of the trial, culminating in the verdict. This was, in fact, a manner in which the case was approached in the regional court. The appellants were charged with the offence of robbery with aggravating circumstances, and they were convicted as charged. The convictions were thus based on a finding that the aggravating circumstances had been proved beyond a reasonable doubt. The doctrine of common purpose would, however, not have assisted in proving any dolus on the part of the first and second appellants. It is settled in law that this doctrine can only be invoked for the purposes of proof of causation as one of the elements of a crime. It cannot serve to impute the dolus of one person to another. CS versus Malenga, 1963, 1 SA, 692A, 694F to H. We are accordingly of the opinion that the inclusion of the phrase or an accomplice in the definition of aggravating circumstances in Section 1(1)(b) of the CPA Criminal Procedure Act is inconsistent with the Constitution and therefore invalid. In keeping with the court's reasoning in Masingili above, the state will have its work cut out to transfer intention to all accused in this matter for each count. Causation refers to both factual and legal causation. Although Masingili deals with aggravating circumstances as the element of robbery, it is submitted that the court's view on transferring dolus with the proof of common purpose and thus conspiracy evenly applies to this matter and its accused. A wrongful act that was a causa sine qua non of the loss or damage does not necessarily result in legal liability. The sine qua non maxim is expressed as the but-for test. But for the action of this applicant would the results have ensued. The state cannot submit with confidence to this honourable court that causation will be proved, both factual and legal causation, and further, that intention in the form of dolus eventualis, directors or indirectors, that's intention, will be proved in respect of all counts for all accused. Counts 4 and 5 refer to unlawful possession of a semi-automatic 9mm pistol and 6 rounds of ammunition. It is unclear whether there is more than one pistol with reference to the charge sheet and annexures provided to my attorney. I submit that the state intends to proceed on joint possession, which is addressed hereunder. With reference to the discussion on intention, transferring intention to a co-perpetrator and causation, one has to look at counts 6 to 10, which is attempted murder. The state would presumably wish to proceed with dolus eventualis on attempted murder charges. I submit that proving same will be an onerous task for the state. In highlighting the charges individually, the Honourable Court is asked to consider that the multiple of charges during my bail application is simply to bolster the state's opposition to me being granted bail. It is unlikely that joint possession will sustain counts 4 and 5 during trial, and further that intention would be a prickly pear to address where transfer of intention is concerned, and further to prove intention in respect of attempted murder of bystanders, which is account 6 to 10. An identity parade has not been held in terms of the rules set out in the Criminal Procedure Act to date hereof. It is apparent that the identification of all accused in this matter stands to be tested at trial. Positive identification in terms of the rules is not before court to confirm the strength of the state's case. The state clearly stated that it does not intend to hold the identity parade. The identities of all 5 applicants and the outstanding accused 6 and 7, in demande ×2, have been revealed in the media and exploded on all screens, on television and social media. Speculations run high, but it must be considered that doc identification will carry no weight at trial, as the accused have been presented as the 7 accused implicated already through the media. The CCTV footage of the incident has been available on social media since the day of the incident. The person appearing to be pointing what appears to be a firearm at Mr. Forbes is clearly masked and small or short in stature, as speculation grows as to whether the alleged gunman is indeed a small female. I am by no means a short person. The footage may not bring the state's case against me further at trial. The firearms in count 4 appear to be undisclosed amount of firearms. The make, model, and caliber is unknown at the time of this application. The charge is not one that can be answered in this form and stands to be amended. Unless the state amends same, it stands to be quashed on application after receipt of the further particulars. I am expected to answer to charges during preparation of my bail application before this honourable court. Reference is made in plural to firearms. More particularity on this will be requested from the state. In the absence of the following, I submit that the counts with reference to the charges against me will not necessarily amount to conviction. Should all of the below be provided by the state to court during my bail application and to the trial court, the state stands on a stronger footing, failing which the state's case remains weak. That there were bullets recovered and removed from the deceased. The bullets were properly transported, secured, chain, and identified as belonging to the spent casings found on the scene, and further identified as having been fired from one or more of the firearms seized. Fingerprints lifted from the spent casings and firearms match my prints, showing that I was in physical possession at the time of the alleged possession. If so proved, can it be linked to the time and period of the offence? Recent possession or possession thereof on one occasion cannot serve an artificially created presumption that possession was indeed at the time of the incident, linking all acts to myself and my co-accused. Your Worship, if I may please request a body break. I think it's the heat, the perspiration is absolutely pouring down. Just 5 minutes just to rinse my face, Your Worship. I would appreciate that.
Okay. 5 minutes, you say?
Thank you, Your Worship. I'm indebted to the court.
Court will adjourn for 5 minutes.
Susan, are you going to take this and let your secretary fix it? We're going to fix it together. Yeah. Go to
Just gonna try to top it a bit.
Yeah.
Jesus, I'm indebted to the court and to everyone present in court for indulging me, Your Worship.
Thank you.
If I can proceed, after subheading D, I submit that bullets 41A to D supra would need to be proved at trial to secure a conviction on counts 1 to 10, and further submit that the same bullets 41A to D are lacking at the time of my bail application. Where does this leave the state's case at the time of my bail application? One can only draw one inference, which is that the state's case is fatally lacking at the time of our bail application. It is apparent that the state alleges all accused applicants conspired with one another and acted in concert in the alleged incident, causing the related results as set out in counts 1 to 10. It is unclear where the state recovered firearms. Joint possession will be the state's stance on possession of the automatic firearms. Our courts are clear where joint possession and presumption of possession are concerned. Extracts of same are set out below. Joint possession and presumption of possession. The Firearms Control Act 60 of 2000 governs possession of firearms, inter alia and specific section 117. It is submitted to have been relied on by the state to arrest, detain and charge the accused at the onset as set out below. I'm going to the relevant section that is highlighted here, subsection 117(2). Wherever a person is charged in terms of this act with an offence of which possession of a firearm or ammunition is an element, and the state can show that despite taking reasonable steps, it was not able with reasonable certainty to link the possession of the firearm or ammunition to any other person, the following circumstances will, in the absence of evidence to the contrary, which raises reasonable doubt, be sufficient evidence of possession. Possession in our courts, at paragraph 44, our constitutional court addressed the validity and constitutionality of presumptions created in legislation with reference to possession, be it cannabis, firearms or sundry goods. The Constitutional Court heard the matters relating to case CCT 1995 and S versus W. Mbata and CCT 3595 and S versus Prinsloo, heard on 16 November 1995. The judgment was delivered on 9 February 1996 by His Honourable Langa. The Constitutional Court held as follows. The presumption is not only too wide in its application with regard to persons, it also casts a heavy burden on those who are caught by it to disprove guilt. In the facts in this case of S versus Nchmela and others 1994, 1 SACR 518A gives some indication of the seriousness of the task facing an accused person if he or she is to discharge the burden of proof. Of the 3 persons accused of possession of one firearm, in that matter, 2 elected to give evidence to rebut the presumption. They were both convicted. The magistrate ruling that the evidence was insufficient to dislodge the presumption. The third, who had decided to remain silent, was also convicted, there being nothing in his case to gainsay the presumption. In another case, that of S versus Makunga and others, 1977, 1 SA 685 AD, the remarks of Vessels JA at 699A are illustrative of some of the problems inherent in the practical application of the presumption. There was an onus on each one of the 7 accused to establish by a preponderance of probabilities that he was not in possession of any one of the 6 firearms found in the hut. In my opinion, no one of the accused succeeded in discharging that onus. The mere fact that on the evidence it was probable that one unidentified accused was in possession of the toy pistol is wholly insufficient to discharge the onus which rested on each one of the 7 accused. Based on the assessment of the potential effect of the provision on innocent people, I am not persuaded that the presumption as it stands satisfies the requirements of reasonableness and justifiability. I am fortified in this conclusion by the fact that it has also not been demonstrated that its objective, that is facilitating the conviction of offenders, could not reasonably have been achieved by other means less damaging and constitutionally entrenched rights, to constitutionally entrenched rights. I accordingly find that although the provision in question is a law of general application, it has not been shown to be reasonable as required by section 33(1) of the Constitution. It is furthermore so inconsistent with the values which underlie an open democratic society based on freedom and equality that it cannot be said to be justifiable. Joint possession in our courts. The Gauteng High Court Local Division held at Johannesburg in case number A552-2013 an appeal filed by T. Zumani and M. Palakazi and M. Mate against their conviction of joint possession of a firearm. The appeal court held as follows. The principles applicable to joint ownership have authoritatively been dealt with, laid down and explained in a trilogy of cases, the ratio in S versus Nkosi, was proved in S versus Mbuli and thereafter explained and summarized by Joffe in S versus Motsema. I'm not going to give the full citations here. It is in the affidavit, Your Worship. I therefore conclude that on the basis of S versus Nkosi and S versus Mbuli, the law may now be stated as follows. There is no rule of law to the effect that when an armed robbery is committed by two or more persons with a common purpose to commit the armed robbery, joint possession of weapons used in the robbery is to be inferred. Joint possession of weapons can only be inferred if the facts proved leave no room for any reasonable inference other than that. Each participant in the common purpose to rob who had physical control of a weapon intended to not merely use it, but also to possess it, both for himself and also on behalf of one or more other participants, and each alleged joint possessor who did not himself have physical control of a weapon intended that one or more of the weapons should not merely be used, but should also be possessed by another participant on his behalf. Before applying these principles to the facts of the present matter, it is necessary to consider the presumption created in Section 1172 of the Firearms Control Act, the relevant portions of which read as follows. I have already read this into the record. That is 2, wherever a person is charged in terms of this Act with an offence of which possession of a firearm or ammunition is an element, and the State can show that despite taking reasonable steps, it was not able to, with reasonable certainty, to link the possession of the firearm or ammunition to any other person, Your Worship. This has not been done. Your Worship, I'm going to move on from there down to the following page, where I have a highlighted portion. This finally brings me to the question of whether the State, not being aided by the presumption, has proved joint possession of the firearms by the occupants of the BMW. In my view, at best for the State, the accepted evidence shows that occupants of the BMW were all aware of the presence of the firearms in the vehicle. That, however, is not sufficient to find that the occupants possess the firearms jointly. Mere knowledge of the presence of the firearms, as rightly conceded by counsel for the State, is not sufficient to establish joint possession, which is my emphasis. We're moving on to paragraph 46, Your Worship. I am unaware of where or whether the vehicles were found, where the firearms were found, and in whose name the vehicle is. The information is presumed to form part of the State's case, but I am unable to comment further on same, bar for asking whether the State lifted fingerprints from the steering wheel and matched it to any of the accused to assist the court in same. Count 11 is not preferred against me. Count 12, money laundering, is at this time somewhat difficult to answer to, in that I suspect that receipt of any funds by myself before or after the incident will be presumed to be funds that originated from unlawful activities and related to the incidents at counts 1 to 10. I, however, submit that me having had knowledge of the source or origin of deposited or received funds at any time is simply brevity on the part of the State. Cash payments, trading stores, and electric transfers occurred daily.
The Honorable Mr. Dlamini is saying the same was not done with number 1. I thought I heard that, but...
Mr. Mlojo.
I think it fell through the cracks. That was, it would appear that was not done in number 1 as well.
Yeah. Mr. Mkwanazi Lindoguhle, your statement was read into the record late earlier on, and it was received as Exhibit B. Do you confirm the content thereof? Thank you. Harassment of applicant number 4's family by the investigation team.
Your Worship, I'm baffled by the submissions. There is no application before you as to what are the circumstances why those vehicles were impounded, if they were impounded. There's nothing in these proceedings before you with reference to those vehicles for you to issue an order as to what should happen to those vehicles. The circumstances under which they were seized, if they were seized. Such application is not before this court. It may be, it may not be that they are of reference to this bail application. We are still at the infant stage. We do not know. For this court to be requested to issue an order for the release of the vehicles, the court have no clue as to why were those vehicles in the first place impounded if they were, is to ask too much of this court. That aspect, if indeed it happened, my learned friends know which route to take, not to approach you. This has got nothing to do with you. There's no application about those vehicles before you. Therefore, there can be no order you can issue relating to those vehicles. Now, secondly, about the submissions made by Mr. Mlochwa and Ms. Killing. It is always our understanding that the applicant will file an affidavit as a bail applicant, close his case, and if the state wants to respond to those whatever facts that have been laid by the applicant, we will do so. If there's anything in our response they wishes to reply on, they're entitled to do that. However, to reply to whatever we have raised, not to raise new issues, because this is their application. Whatever they want this court to hear about their application, this is the chance. Have they closed their case, we then respond. If there's anything in our response that they want to reply on, in all fairness, they'll get that chance. But should they raise anything new, we are entitled then to reply to that. Because the reply is only to the response filed by the state. Only on those bases, we say we have no problem with the issue. I think even on the first appearance of this matter, when the dates were arranged, it was indicated that this will be an exchange between the parties. Therefore, I have no issue with what is requested by both counsel appearing for accused or applicant number 1 and Ms. Gilling who appears for accused or applicant number 3. Unless there's anything else, Your Worship, those will be my submissions on the issue.
Thank you. Your Worship, I'm going to just reply to one aspect. It's trite law that where there's an application, the opposing party is entitled to answer that, and the applicant is then entitled to reply to that, not raise new issues. We all know that. We don't have to be reminded of that. It's trite law. So I don't understand where my learned friend is coming from with that. Your Worship, yes, there is no application before the court with regard to these vehicles. All we are asking for is an explanation as to why these vehicles have been seized. Nowhere are they mentioned. Why can't we have an explanation?
Should it be given in these proceedings?
Yes. They're not part of these proceedings, as far as I am aware, Your Worship. Not from what I've seen.
No.
Then that answers.
No.
That submission answers what you should do. Thank you.
Is it my understanding then, therefore, that at this point in time, applicant number 2, 4, and 5 are not ready to move their application because their affidavits are not ready, and that would be done on the next appearance?
On behalf of applicant number 5, I confirm the position, Your Worship.
I confirm the position, Your Worship, and also the fact that at 1 o'clock the court has to close. We don't have any option there.
All right. This, first and foremost, the issue raised by Mr. Volmarans with regard to the seized vehicles, I have no information of that. There is no application brought before me with regard to that. I'm not in a position to entertain that because there is no application before me. I'm not going to deal with that. And at this point in time, the matter is postponed to an agreed date, which is the 18th of March, next week, Monday, for further proceedings. Applicant number 1 to 5, please rise. Matter against you is adjourned until the 18th. You'll be kept in custody at Westville Correctional Services or Correctional Institution until then.
That will then, Your Worship, complete our role for today.
Corrections.
Rise.
Once I've got you on WhatsApp, then I can transfer to my left. Okay, thanks, Lawrence.
Okay, thank you.